Well, good morning, everybody. Welcome to the first meeting in the new year, 2016, of the committee between the Santa Ynez Band of Chumash Indians and the County of Santa Barbara, represented by the Chairman Vince Armenta and Vice Chairman Kenneth Kahn and Supervisor Adam and myself for the county. We also have county staff here with us, and so we welcome you, and we're glad that you're with us today. We're going to go ahead and open the meeting, and we'll start with public comment. I just have one request to speak from C.J. Jackson. Again, just to remind that this public comment time is to comment on items that are not on today's agenda. So not dates for upcoming meetings or sovereign immunity or the review of the proposed term sheet or the overview of Chumash properties that's going to be presented. So, Mr. Jackson, you'll have 3 minutes.
Microphone. I'm going to have to grow. Ain't going to happen. Good morning, Madam Chair, Chairman and Vice Chairman, C.J. Jackson. I always approach public comment a little flat-footed because I'm trying to tool to the agenda that you have. So I'll focus on just 2 items. One, a point that was raised at the last meeting, which I think was either misstated or incorrect, and I just want to address it. Vice Chairman Kahn, you made the comment that for the last 15 years, the county and the community have opposed tribal housing for that entire period. And I would have to say that over the course of that period, tribal housing was essentially subordinate to other development scenarios that were far more powerfully activating to the community, be it convention hotels and golf courses or the other thing. I think that the community would have been more interested in accepting of housing had that been a component early on. I just reviewed an article from 2004 in the LA Times which talked again about 500 market rate homes on leaseholds. And as a community member, the best that we can do is to respond to what's in the public forum, what's the public discussion, what's coming from the parties involved. And so the discussion of housing and critical housing needs, et cetera, is a comparatively new element in the discussion compared to what we have been experiencing before. And the other is an observation that the parties here, the county and the tribe, seem to be talking past each other on one critical element. I don't know where this will fit in the discussion, but it appears that the tribe's position is to acquire property and ask the county which property they can to take into trust, but the county has a duty and an obligation to evaluate the burdens and the implications and ramifications of property, so it makes it somewhat flabbergasting to be able to say, well, just take property into trust without an understanding of what is going to happen there. And so I've watched the last 4 meetings where the parties seem to be talking past each other on that issue. So I'm hoping that the discussion coming will clarify that. And I thank you once again. I think this is a great thing that's happening. Thank you.
Thank you, Mr. Jackson. I have had 2 more requests to speak in this general public comment time. Doug Herthel, to be followed by Larry Jett.
Good morning. Happy New Year. We got a big year ahead of us. I think Polo just wants to present the transcription of the minutes or of the meeting for October of 2013. And the highlight of that meeting, of course, was overall opposition to fee to trust, and the board voted 4-1 against fee to trust. So these minutes are quite detailed. They're every word for word. I'll just give that to the clerk. So thank you.
Thank you. And then our last speaker in public comment is Larry Jett.
Good morning. My name is Larry Jett. I'm a resident of the Santa Ynez Valley. Our properties may be 500 lineal feet away from the along baseline from the border of the Camp 4 property. I develop real estate for a living. I have done it for over 40 years. I've had an instance where even though I was trying to get a piece of property, a building permit on it, on a property that was zoned for what it was, it took me over 7 or 8 years just to go through the various processes in order to do that. And then having done that, even though it was zoned for that, I had to give away half of the land for various community interests. So we built our home about a little over 5 years ago at this. It's a 55-acre piece, and part of the desire to do that was because of the community plan that the County of Santa Barbara had put together, and I understand it took like 10 years to do it, and it was a communal effort of what the residents of San Ynez Valley wanted. And so we went ahead and built our home, and I'm actually absolutely dumbfounded because this land is zoned, I think it's one house per 100 acres. And I kind of got brought up in a manner that you respect your neighbors. And I can appreciate, because the system that I grew up in, I was able, to the best of my ability, following rules, and have been able to make a living. And it's my understanding that the folks that make up the Chumash tribe have been very blessed with the amount of money that they're able to make from the casino. And I constantly hear from Mr. Armenta in the media how he feels that the tribe is abused and mistreated and misunderstood. And to my knowledge, I don't really know of anybody that has a particular distrust or disfavor or hatred of the members of the tribe. I do know there's a lot of us that really are disgusted with what you're trying to accomplish. And I don't know where in God's green earth, I mean, I thought we were all citizens of the United States. And I cannot get my head around why, just because somebody happens to be Native American, why they get a free pass. I know in my development career, I have never received a free pass. You just go do it, and you do the best you can and hope for the best. And I have no idea what your plans are. I really don't. I hear all kinds of rumors of you're going to do this and you're going to do that. But what I know is right across the street on Baseline, there's going to be a development that's being proposed that's way beyond one house for 100 acres.
Thank you, Mr. Jett. Your time is up. All right, we'll go ahead and move on to our first regular agenda item, which is the adoption of our action minutes of the last meeting on December 10th. Generally, we just kind of do this by consensus, so unless there's any corrections or changes from anybody on the subcommittee here, we'll just go ahead and adopt those by consensus. Is that fine? Seeing some head nods here. All right. So we'll go ahead then and go to discussion item number 2A, which is the overview of the Chumash properties to be presented by the tribe, and there is an attachment with the PowerPoint presentation they're going to do. So, Chairman, just who from the tribe is going to go ahead and present this? Okay.
Good morning. Good morning. Sam Cohen, Government Affairs Legal Officer, San Ynez Chumash. We're going to kind of do a general overview of the Chumash properties. These are all the properties, including from the reservation all the way to Highway 154, including APN numbers. The biggest parcel is what we call the 356 acres. Some people call it the 360 acres. Some people call it the Triangle property. And it continues from Meadowvale eastward to 154. all north of Highway 246. We called this a sphere of influence. That's based on a very, very loose analogy to the LAFCO sphere of influence that Solvang has, Buellton has. But really, it's kind of a description of the existing tribal properties, starting on the very east in purple with what we call Camp 4, the 1,400 acres. Going west next to the triangle property, the 356 acres. And then the tribe owns various parcels north of Highway 246, going all the way west of Edison. That's Edison right there. And that is the what we call the 6.9 acres just to the west of that. That was approved to be taken into trust in 2005 by the Bureau of Indian Affairs and litigated until 2014 in the Interior Board of Indian Appeals, and is still on appeal at the Federal District Court and the Ninth Circuit. Then if you go south, even though the reservation technically crosses Highway 246, the majority of the reservation is south of Highway 246. There's the, what do you want to say, the original 99-acre reservation. And then in the 70s and 80s, there was an addition for a HUD housing subdivision, sometimes referred to as the Upper Reservation. We kind of did an analysis of just what are the planning aspects of the various parcels. The bulk of the triangle parcel is grassland and is currently being grazed. There's, the headlands of the Zanha Dakota Creek drain through the 356 acres, going to this parcel that the tribe bought from Mowree, which is recreationally zoned and currently has an organic farm, and then heads through the reservation in one of the two tributaries of the Zanha Dakota Creek. This is some critical habitat designations under federal law. The only one that crosses over is the vernal pool fairy shrimp, which previously couldn't be tested, but actually with all this rain, we could test for vernal pool shrimp. I guess the nearest analog to a vernal pool fairy shrimp is the old sea monkeys that you used to see in the back of comic books, or the brine shrimp you might have fed some of your tropical fish in your youth, or maybe still, who knows. Anyway, so that's the vernal pool fairy shrimp habitat. But it's designated. I mean, it doesn't, technically, no one knows if they have vernal pool fairy shrimp, but it's designated as a possible critical habitat. This is wetlands inventories from the federal government. There are no wetlands currently designated for these properties. Sorry. The nearest wetland is just the southern third of the reservation, which is an intermittent swamp. There seems to be a hard rock formation that takes the waters of the Zanha Dakota Creek and forces them to the surface in the last third of the Santa Ynez Reservation. And so it has a designation as a wetland under the three-prong test, which we won't go over today. And floodplains, we've spoken about briefly. You can see how there's drainage through Camp 4, and then it crosses over to the 356 acres, or the triangle. It's not really a triangle, you know. I mean, the triangle ends right about there. But I guess that works. It crosses over the 356 acres, crossing over the Mowree property, and then continues on into the reservation through one of the tributaries of the Zanha Dakota Creek. Land use designations. We've heard a little bit about Camp 4, Ag 2 100. And then the Triangle property is Ag, I think 40, all right, for the 356 acres. San Ynez has a higher density. And then the Maury property was rezoned recreational in the San Ynez Valley Community Plan. We have some pictures. We have the Chumash gas station on the southeast corner of Edison. We have the former Volks gas station on the northwest corner. 2 years ago, the tribe pulled the tank, 4 years ago, the tribe closed that down and then pulled the tanks. There was no soil contamination underneath the Volks. We have ephemeral drainages. We have actual drainages under Highway 246. And there's some overview of a little bit of the ag. We have additional pictures. This is the Maury row crops. I think it's, and then we have 154 view sheds. There's this structure, I think, is on the 356 acres, and some additional views of the structures. Some more views of drainages and grazing land. There's some a little bit of water tankage and some cattle areas. And I think that's one of the two houses on the 356 acres, which have been occupied for an extended period of time. Anyway, this is contact information for the tribe, and I put my own email up there, S. Cohen. You can also email to the information box at the San Ynez Chumash, but like all information boxes, you may sit there for months until someone decides to clear it. So I thought to put my email up there to give you a slightly expedited response. Thank you very much.
Thank you, Mr. Cohen. Chairman or Vice Chairman, did you want to go ahead and make some follow-up comments? Yeah, it's on. Maybe just bring it a little closer.
Got it.
Okay,
There you go.
Thank you.
So anyway, that was it. But I think, and I mentioned it at the last meeting, I think it's important that we have discussion on the properties that the tribe owns. As the county knows, Mooney Escobar applications have been brought into trust, or been applied to bring into trust. The 6.9 has been brought into trust, and these were the original areas through the land consolidation plan that the tribe abandoned several years ago, which we felt was our sphere of influence. So we thought it was important to bring these up and have a conversation if necessary on them.
Vice Chairman, do you have any comments right now? Okay, thank you. I do have a number of questions, but Supervisor Adam? Okay. You know, I just, thank you for the information. I think it's very interesting, and, you know, we have discussed at various times about taking a more comprehensive look at the properties that the tribe owns and their various status. I guess my first question has to do with, you've entitled this Gateway Parcels, and I'm just wondering if it's, I'm assuming it's you've titled that as a gateway to your property? Is it a gateway to the valley? What do we have a gateway to? Is it to the
And
casino?
Actually, no, it's certainly not a gateway to the casino. It was titled Gateway just because obviously it is the gateway to the valley, it is the gateway to the reservation. It was actually the gateway to the original land that title was held, tribe was held on title originally, but lost in the 1906 decision.
Okay. And then it's somewhere in here, you use the phrase focused EA or environmental assessment parcels. You know, obviously this is the kind of in-depth work that's done for an environmental assessment. You know, we saw it with Camp 4 and the other properties, and it usually comes into a packet of information that goes forward to the BIA for a fee to trust application. So I guess I will ask you, have you submitted this as part of a packet for a fee to trust application to the BIA?
No, we have not. And once we do, obviously all of the necessary reports will be filed, and the county will receive a copy of those as well.
Okay. But this is already putting together a packet to submit for fee to trust for all of the parcels that were just outlined in
Actually,
this.
we haven't even submitted an application to bring those in. The applications that are pending are Mooney Escobar and Camp 4, obviously.
Okay. I probably have some more, but I'll go ahead and turn to Supervisor Adam. Thank you.
Am I on there? There
Yeah.
we go. Got a little delay. So you are informing us that your intent is to bring that in to trust?
Actually, that's not a decision myself nor the board can make. That's a decision that the tribe as a whole needs to make, and that has not even been discussed at meetings.
Well,
Who can't you hear? Supervisor Adam or
Pardon me.
or the chairman?
CJ needed a shorter mic. I need a taller one. Obviously, I'm sitting.
Yeah.
No, these have not, applications have not been submitted for these properties. Have there been studies on these properties? I said no, not for the application, but there have been studies, certain environmental phase ones and whatnot on these properties. That's part of our due diligence, obviously, before we buy any piece of land. Mr. Adam, what was your question?
well, I guess what my point is you're intending, and this is good because we can have this conversation, which is what I asked for in the first meeting, is what's the 100-year plan? And so this is a part of it, and so now you're basically telling us, right, that the triangle.
These lands at some point in time in the future will be discussed at a tribal meeting in regards to what the tribe's plans for this property are. Whether it be farming, whether it be grazing, or whether it be applications brought into trust. I thought this was the conversation we wanted to have. What do we own and where are we going?
Yeah, well,
And
I gotta
will they be a
know what the
discussion?
plan is.
Absolutely.
I got to know what the plan is
Yeah.
before we can really go back and forth. And so I guess the next question is, are there other properties that you have an eye on doing the same thing? I'm trying to get some idea of the scope of your intention over time to build.
Currently, right now, there is no other land in or around San Ynez or around the reservation that the tribe is looking at. I think the largest undeveloped pieces of property belong to Yaney, which borders the reservation, and who's the lady in, Nancy Crawford Hall. We've not even had conversation with them. Quite honestly, I'm not too sure they'd sell to But I know the county is aware of, or perhaps some of the board members are aware of the tribal consolidation area plan that we submitted, which was all part of that 1906 decision.
Okay, so are you telling us that that's an area that you're confined to in your own mind, or is it, see, because I read the environmental assessment of the 1,400 acres, and it said that the total aboriginal claim was from Malibu to Morro Bay to Bakersfield. So is that the area we're talking about?
That is certainly not the area.
Okay.
The TCA that we withdrew would have been the area that we would have considered.
Okay, the TCA, so in your mind, the TCA is the maximum extent possible?
Yes.
Okay, all right, well, that's good. I'm glad to hear that, because that at least gives us some kind of an outline of what your intent is. Thank you.
So I remember when we asked about these properties before, as far as, you know, what your intention was to do with them, because they do have this existing zoning on them. I remember the vice chairman said that the tribe hadn't discussed, you know, what possible use you would have on it. But in order to submit an application for a fee to trust, you would have to express some intent as to why you needed the property in trust, you know, and how you would use it. So even though you're kind of taking steps, it looks like, to put together a package, there have not been any discussions yet by the business committee or the tribe as to how you would see utilizing that property.
And you're correct. As we submit an application, there has to be a use and a need identified in the application, and there has been no use nor need that has been identified. There's been no discussion globally with the tribe on this.
Okay. And just to follow up on Supervisor Adams' comments about the tribal consolidation area, and Mr. Cohen's use of the term sphere of influence is a very loose analogy to the LAFCO process. You know, as I sit on LAFCO, I'm obviously very familiar with it, and you know, when jurisdictions come forward with an application for a sphere change, it's not an annexation, but it does express a future intent to annex in that area. And then at the time of an annexation, you know, would not go forward until there had been a negotiated property tax exchange agreement with the county. So an application can be submitted to LAFCO for annexation, but it can't move forward till it goes through that process with the Board of Supervisors. Obviously, this process through the BIA does not require that, and obviously that's why we're having these meetings to try to fill that gap. But also with a sphere of influence, you know, for a city, that can be extended over properties that they don't own. At the time, it can be in the county's jurisdiction that are owned by others, and but with the intent to annex them. I think that, you know, needless to say, when the map for the tribal consolidation area was put forward in your application previously, that aroused a level of concern in the valley, and I think in other parts of the county, that, you know, other activities by the tribe had not raised, because it clearly is an enormous area, and with many, many property holders that have property within that area, besides the tribe. And there was a great concern expressed about, you know, what that meant to have their properties mapped within this area, what that meant for property values, what that meant for disclosure for real estate purposes. And of course, it, you know, was very concerning to the county, so we did file that litigation, and I think some others did as well. And then when the tribe dropped that application, then the litigation was rendered moot. But of course, that in no way was in any way preventing the tribe from moving forward in the future with resubmitting the same map or a similar map. So I guess that's my next question then. Is that something that the tribe then is considering to do in the near future, again, as a part of any of these fee to trust applications?
Actually, the tribe has no intention of refiling any type of tribal consolidation area plan, if you would. It was dropped by the tribe, I think, because it was misunderstood and misspoke about both at the county level as well as the public level, which caused a lot of chaos and misunderstanding within the community. But at this point in time, we have no intent of refiling TCA.
Okay, thank you.
And I think you brought up an important point in regards to LAFCO and applications for cities and whatnot to bring to annex land into their jurisdiction. They are not approved until they go through a process with the county where there's an exchange of taxes. You're correct in saying that the applications when to bring land into trust does not have to go through that process. That's a very correct statement. As a matter of fact, the Bureau of Indian Affairs and the Department of Interior frown on the thought that a county or a city could possibly even tax a tribe. So you had that correct. Not only is it not necessary in the application, it is extremely frowned on by the federal government, the idea that a local government could possibly tax a tribe.
Well, I do understand that, and I think that this kind of comes back to the purpose and need for a tribe to take land into trust, and the benefits of not being taxed that go along with that. And so, you know, clearly housing and tribal facilities, which is what you expressed for Camp 4, are considered, you know, to be high priorities for tribes and for the Bureau of Indian Affairs. But you are requesting, you know, those uses on Camp 4, which I guess is why I'm curious to know what the tribe's going to decide the need is for Fee to Trust on these many other parcels. Supervisor Adam, did you have
Yeah,
other
I'm
comments
just-
before we leave this?
I'm just confused now because I thought what you told me was that the TCA was the kind of the outline of what your future intent would be to expand to. And then you just said that you weren't going to bring a TCA back. So are those two statements not inconsistent? Because it initially seemed to be inconsistent to me, but maybe now I'm understanding what you mean. You're going to do potentially smaller incremental requests for annexation within that boundary and not do a quote TCA unquote?
No, I had made that comment in regards to the comment that Supervisor Farr, or actually you had made that said from Malibu to Monterey as far inland as Bakersfield. That was never the intent of the tribe. It was simply a fact that was in the application. We're not going to refile a TCA, nor have we ever intended to file a TCA that included those properties.
Those properties being the ones inside that line? Or outside the line? Outside the TCA?
Outside the line, and
Outside the
actually,
TCA line?
yeah, and the TCA was just an identification of land that the tribe was the map of the land that the tribe was on title to up until 1906.
Okay.
It was for identification purposes.
Okay.
Thank you. I do have one request to speak on 2A from Bob Field. If there's other requests, this would be specifically on this overview of Chumash properties and this discussion. If you have other speaker slips for anything else on the agenda, you should get them to Ms. Moss-Message right away. Mr. Field, you have 3 minutes.
Good morning, all. I wonder if we could get the
You need to
exhibit
speak.
back up of the gateway parcels. I'd like to speak to the exhibit.
And
The one that showed in color the parcels that the tribe owns, yeah. I'd like to make 2 points, if I get to the second one. First of all, just as kind of the baseline for part of the concern here, and I really say this for our supervisors and for the tribal representatives, if those parcels had been acquired by, and I'm going to try to find a very popular American corporation, by Apple Computer, we might have a meeting this big or larger with Apple in here asking them what the heck they have in mind. This is really out of scale for normal development in a community. If it were Harrah's or the Hyatt Corporation or, let's get colorful, Donald Trump, who had bought all that property, this would be one exciting meeting. So I don't think you guys should take too personally the fact that the community is concerned, because just in general, that kind of domination in the community is concerning. Number two, I'm going to go for this. The unique thing about this is the request to take that off the tax rolls and to remove it from county land use controls. Let me focus on the tax use side. It was only 10 or 15 years ago that the tribe and the tribal members were, to some extent, dependent on government services because of their underprivileged, less advantaged position. Well, due to some hard work and some good luck, you folks are now the most economically privileged people. The government provides services to the underprivileged from the taxes it takes from the more privileged. And I'm going to call on your higher nature to recognize that you're part of this community and that as privileged people you pay taxes to help those who are less privileged. And, I haven't been broke for 50 years, and I remember what it's like. You guys have been about 10. Call back on your memories. Recall what government does for people who are underprivileged and get that they do it with tax money. And I would suggest you pay taxes and take pride that you're able to. Thank you.
Thank you, Mr. Field. Our second request to speak on 2A is Andy Culbertson.
Good morning. Andy Culbertson. And at first I want to say that C.J. Jackson and I would like the microphone not set at Bob Field's height in the future. First I want to thank the band for bringing forward a description of their properties. I guess I saw their properties on the map behind Mr. Cohen. I know what they own. What I was more interested in and what I think the December meeting, Supervisor Adam, I believe it was, wanted to know is what's your plan? And what I hear Chairman Armenta saying, and I'm not questioning that, but what I hear is that there have been tens of millions of dollars spent acquiring large properties where there is no plan. It is incumbent upon the county to do a plan then. All right, to try to inquire. I know you think you have the San Ynez community plan, but it is so restrictive that it appears to be precipitating fee to trust applications. So, and while there's no present intent to do one, I think that'll change. I think it'll have to, because the land use that's assigned to these parcels is too restrictive. And I think the county should initiate immediate amendment to the San Ynez Community Plan to open a dialogue with the band to provide a way forward on this land. We didn't choose to buy it, although I would have taxed myself to do it, all of this land. But I believe it is important for the county to initiate this. I've said this many times. Now, in terms of the tribal consolidation area, if the band feels that that is part of their Aboriginal land claim, they should buy all of it. That's fine with me. I just don't want it into trust. That's not part of our community fabric. They have land in trust, apparently, on the reservation. This is not like the Chickasaw or the Cherokee. This is not a very large band. I question thousands of acres in trust and the impacts on this county. But I also find it aggravating that my county hasn't chosen to move forward with an amendment to the plan and open that dialogue through our processes. And that is what I asked the county to do.
Thank you, Ms. Culbertson. Next speaker is Richard Crutchfield, to be followed by Doug Hertel.
Good morning. I was going to make a lot of remarks about, or congratulatory, point out some things the tribe has accomplished in 2.5 decades in education, their environmental concerns on the property they have in trust, and they've resurrected a language. I respect all of those. What I want to cut to is to try to express something that everybody in the valley, I think, experiences, except the tribal members. And I'm going to call that, for lack of a better word, a background anxiety, that people are always wondering, what are the tribe's plans, and how is it going to affect us? And taken it to its extreme, it could be called a fear. And I don't think to operate within a feeling of fear is going to be very productive in terms of the kind of agreements that may be potential and possible. So I think whatever the tribe can do to relieve that anxiety is going to really catalyze and move this process forward. There may have been a time when it served your purposes to hold your cards close to the chest, but I think at this point it's going to really help the process if you can discuss as much as you can in terms of your current knowledge what your plans are moving forward. And the challenge is, and I think it's achievable, combine the county's approved plans with the tribe's plans. Thank you.
Thank you. Mr. Hertel will be our last speaker on this particular agenda item.
Thank you. I just wanted to point out that you realize that there's 8 lawsuits filed on Camp 4 by the county, one of them 8 significant lawsuits. And there's one still pending on the 6.9, and there's one on the expansion. And that there's several lawsuits that indicate that this group never had Aboriginal rights to that property, never owned it. So the county needs to take that into effect, that you got to be looking out for the group of people that live in the county and pay taxes, and not just believe everything that's written down 5 minutes ago. So the fact that they didn't have Aboriginal territory, the governor report said that, and it's definitely in the 1906 ruling. That's what Mr. Armenta said before that. Well, they did not live up there. So that's important to know. It's also important to know that you're actually negotiating with, I think, Wells Fargo's bank and the U.S. government. So if, in fact, someone puts us into Feed a Trust, our neighbor is the U.S. government. They will own that. And I don't think that's really what the county wants to do. And the bank will own it too. So it's the bank and Wells Fargo that you're dealing with. These guys are just helping out. So be sure and consider that. Thank you.
Thank you, Mr. Hertel. All right, we're going to go ahead and move on then to our second discussion, item B, which is the status report on the discussion between councils on the waiver of sovereign immunity. Mr. Cohen, did you want to start out and make any comments?
We have met previously. We've made substantial progress, and I think we put aside the waiver for a short period of time to allow a response to be developed to your proposed term sheet. But I defer to Ms. Van Molen.
Okay. Thank you, Mr. Cohen. Ms. Van Molen?
Madam Chair and Supervisor Adam, Chairman Armenta, and Vice Chairman Khan.
Just got to have closer
I
to
was
you.
a little closer. Does everyone hear me now?
Yeah.
Okay, thank you. So I think Mr. Cohen, I gave an update at the last meeting on December 10th, that Mr. Cohen and I made good progress on discussions of waiver of sovereign immunity. We've continued those discussions, and I expect at a future meeting we'll be able to report back with some more specifics.
Okay, so the emphasis for the tribe was to go through the term sheet which we had presented the last time, and so that was kind of, more discussions on this were kind of put on hold in order for them to focus on the term sheet.
Madam Chair, that's correct.
Okay, thank you. All right, I don't have any requests to speak on this. Item 2C is a review of the proposed term sheet, and you know, we did provide this to the tribe a few days ahead of our last meeting in December. The tribe had not had enough of an opportunity to review it nor have their business council meet. And so they have had that opportunity now. Unfortunately, we just got it this morning, so we haven't had a chance to look at it. So I'm going to call for about a 15 or 20-minute break to allow all of us to review the tribe's response to this, and then we'll come back together. everybody. We're going to go ahead and reconvene after the break to give us an opportunity to review the tribe's response to the county's term sheet. And so I think we'll just go ahead and we'll turn to the tribe. Chairman or Mr. Cohen, if you want to go ahead and walk us through your comments. I do want to say on behalf of both Supervisor Adam and myself and staff that we really appreciated the tribe's thorough analysis of it and also the structure, which makes it very easy to compare the points that we laid out with the tribe's response to that. So.
Thank you, Supervisor Farr. Again, we had the opportunity to review this and apologize for not having enough time last month to do it. But we certainly are glad that this process has taken place. I think it's something that we have looked forward to for several years to open up communication in particular in regards to Camp 4 and the Feed a Trust application, as well as the legislative process that it's working through. Mr. Cohen will go through the presentation on this, but I want to assure you from myself as well as the board that we appreciate the county responding, and we think it's great that we have the opportunity for this dialogue. Mr. Cohen?
Very good. Very good. We have we'd like to thank the county again for providing us with this proposal. We've gone through each section and have separately responded. I believe it's on the county version is on the board, and copies of the tribal response were handed out at the front of the room. The county proposal starts with a preamble, or at least we call it a preamble. It's some text at the beginning, some bullet points. In essence, the county makes the argument that since you only have 143 one-acre parcels in the preferred environmental alternative, plus some other infrastructure, that you really only need to take approximately 220 acres into trust. The Bureau of Indian Affairs Feed a Trust process is sort of built on county land use designations. And Camp 4 is actually 5 legal parcels. It's really 4 legal parcels, and then there's kind of the very, very western edge along 154 is the smallest legal parcel. So in those 5 legal parcels, you really can't subdivide out 220 sub-1-acre parcels. Well, at least under state law, you'd have to follow the Subdivision Map Act amongst other state rules. Therefore, the preferred 1-acre alternative would include all 5 parcels, so we could not just do 220 parcels. The second preamble is the county does remark that they would support some Feed a Trust alternatives, and the tribe, of course, has made this a little stronger, saying the county would support all Feed a Trust alternatives. In terms of actual structure, there are 7 points, 7 major headings, and I'll just go through each one individually. You can follow along on the screen. No, you can't. Because it's gone. Anyway, I'll try to summarize it in my unbiased fashion, as you can expect. The first point is waiver of sovereign immunity. I do want to thank County Council for working with us on this alternative. I think as of now, the preferred alternative, there are 2 alternatives. One is the original cooperative agreement, sovereign immunity waiver model, and the second model was the current tribal state compact that was adopted in 2015 and recently went into effect. And so far, I think we're leaning towards the new tribal state compact version. And that's currently in progress, and there are just a few details left to discuss. The term, the original cooperative agreement was for the expiration of the original tribal state gaming compact in 2020. We followed the new gaming compact expiration of 12/31/2040. with some type of extension protocol prior to the end of that agreement. I think we decided to put a bulk of our effort into number 3, municipal finance and fiscal considerations. The current property tax regime, as these guys are able to explain it, is a 1% property tax on the assessed value of property, and that's divided between the county and various schools and special districts in the unincorporated areas. But on additional research, we found a different model for division of these property taxes with incorporated cities. All right, so even though tribes do not consider themselves to be cities, that is a different model that we discovered. And so if you look, you'll see some handouts. And we were able to get from Buellton a copy of their property tax breakdown. And you'll see that Buellton keeps 16.2% of the 1%, and shares with the county 13% of the 1%. Although and then the county's original offer was 38% of the 1%. So there is at least agreement that 1% is not the tax rate. And then the question remains as to the county share of 38% in the unincorporated area, or a Buellton example of 13% to the county of the 1%, or some other percentage. There's little c, governments themselves own real property all the time, federal, state, and cities. Those lands are not taxed, so the tribe takes position, and we hope you do also, that the tribe is a government and it is not taxed. And then property taxes were to be assessed on private residential improvements phased in over time, and that's the third handout that we provided. And that shows 143 houses built out over 10 years. That's 14 houses a year, but obviously we have an extra 3 houses in year 10, so there's 17 houses in year 10. We use the Buellton model for this chart, with 13% going to the county. And the Buellton portion we're expecting to leave with the tribe and not give it to Buellton, obviously. But I'm sure they'd accept it if we ask. So anyway, we currently have reservation-based mortgages on leaseholds. It's a HUD program, and these leasehold mortgages generally assess on reservation houses at around $500,000 per structure. So we use the $500,000 figure and multiplied it by 1%, and then took the county percentage of 0.13 of 1%. So and so that's if you want to be generous, you can call it the tribal property tax model. If you don't want to be generous, you can call it in chart. All right. The last thing is there is some question as to sales tax or transient occupancy tax. Certainly, cities don't pay transient occupancy tax to the county. Cities also have a variety of other taxes, utility user taxes that the county doesn't collect. Although there is some split of sales tax, for now the tribal position is no sales tax or transient occupancy tax. Non-economic impacts, that's section 4. The tribe is governed by all federal laws, and the tribe has its own ordinances, and the tribe will continue to enforce all these federal and tribal laws on tribal lands, which would include all the mitigation measures in the environmental assessment as approved by the Bureau of Indian Affairs in the finding of no significant impact. And we also talk about enforcement about upstream water users, as the tribe has for years had various degrees of runoff from these upstream users, which we for now dilute with the NPDES permit and the wastewater treatment plant for the benefit of downstream users. Section 5 is future of land use and limits. The tribe took a different approach here. The county was asking the tribe to respect the Williamson Act for the remainder of the non-renewal period of 9 years. The tribe, after doing additional research, found that the county can cancel the Williamson Act contracts on Camp 4, which results in a prepayment, a cancellation penalty of 12.5% of fair market value. However, additional research discovered that the county can work with the tribe to waive these penalty fees as well, so we included that in the tribe's offer. There is some question as to gaming, and gaming is extensively regulated by federal and state law in the form of tribal state compacts and tribal law, all of which would continue. On Section 6 for infrastructure and service supports, the county's position was the tribe would develop all the internal infrastructure for Camp 4 and then pay the county an impact fee. So it seems a little like double paying, but nonetheless, the tribe does have an existing agreement for road maintenance on Sanja Kota Road, which is the borderline between Gainey and the tribal lands, which might be interesting to review as a model. Other items for consideration, both sides put forward to consider separate agreements for schools and service agencies outside of Santa Barbara County's jurisdiction. So that is the tribal response, and we appreciate receiving the county's term sheet and given the ability to respond, and we thank you.
All right, thank you, Mr. Cohen. I'm going to turn to the chairman and the vice chairman if they have additional comments about the various points. Mr. Cohen. Okay. Supervisor Adam?
Just a couple of questions to clarify, just so I understand. Are you opposed to the, in section 2 on the term, are you opposed to connecting that to any agreement that the tribe may have with the state?
The original cooperative agreement used the compact term because that was the guarantee of the stream of revenue for the tribe. I'll leave it to Chairman Armenta to talk about the new compact.
Which is why there's a reopener, for discussion for extension of the agreement. Right now, the agreement is based on the year 2040, which is when the compact expires, understanding that there'll be a section in here to reopen. A little premature to address that because I'm not going back to the state to amend the compact anytime soon.
Well, okay, I'm just...
But there is a reopener, and we agree there should be a reopener.
Okay, well, are you opposed to the concept of connecting it to any, because the language in the proposal was specific, and I thought it was pretty important in order, I mean, we can have a reopener for any number of reasons, but that one right there can be kind of, one reason you might have a reopener can be a little bit easily solved by saying gaming compact or any other agreement the tribe may have with the state. So in other words, if you're still a tribe and there's still a state, there's still, this agreement would survive.
And that's a conversation we didn't have when we discussed this with myself and the board. What we discussed was, originally it was a 10-year. We understand the county wanted it longer, obviously, so we extended it out to the existing compact. I'm not going to say I am personally opposed to that, but it's certainly a conversation that we haven't had as a board.
Okay, well, that's, if you don't want to tell me that that's a deal breaker issue for you, then I can move
Well,
forward.
it's certainly not a deal breaker. Like I said, we haven't had the conversation.
Perfect, okay. You understand that our position is that, and I'm down here in the 3 municipal finance, we don't see any recognition that there's additional sheriff and fire costs associated with this, or benefit to you, cost to us. And you understand that our position is that all of the money that gets paid at this point by the tribe to the sheriff and the fire is associated with costs and benefits that go to the casino and the existing reservation.
Under 3, I did, because we did have a lengthy discussion on 3F, I assume you're speaking about.
I don't have a 3F on mine.
It's your original proposal.
Oh, okay. Okay, it's on ours. All right. I was looking at
We don't believe that the funds that we're paying the sheriff and the funds that we're paying to the county fire department are all necessarily related to or impacted by the casino. As a matter of fact, when we came up with the agreement with the sheriff, we analyzed the numbers that came directly from the county in regards to the amount of usage we use on those services, which is only about 25% of what we're paying. I'm not saying that there is not a portion that is there to mitigate effects from the casino, but I can say well more than 50% of it is being paid, well, for lack of a better phrase, just because we're nice guys.
I would stipulate to that. I think it's more important for me at this point not to achieve agreement on anything. I just want to understand your position and have you understand ours, and then we'll take this back and do something else and produce a writing for you. And then next time we get together, then we'll respond to that. We'll all respond to that, and so.
And I would agree with that. I think, now what we're trying to do is ask some clarifying questions. But, there are a number of things on your proposal that I think Supervisor Adam and I feel that, we need to go back and discuss with county staff, whether that's, the sheriff and fire or public works or the auditor controller, that's in the, and the assessor on some of the assessment issues. And I think that, as long as we're talking about 3, I'm just wondering whether you or Mr. Cohen could explain your 3A about final after 4 years with owner reassessments. I don't quite understand what that means.
Yes, ma'am. So currently, we actually have a property tax appeal on Camp 4, and that's actually the process. When there's a transfer of ownership, the Proposition 13 reassessment occurs, and then if you have 4 years to ask for a reassessment within that period of that original assessment, and then after the 4-year period, the owner can ask for a separate reevaluation. That is your existing process. I may have inartfully stated it, which probably is true, but that's your current process. And I guess I should add on the sheriff's agreement, the sheriff included mutual aid for the entire valley as one of his provisions in that agreement, even though those deputies are included on the reservation. And then on the fire agreement, the tribe staffs the EMTs, well, paramedics, at both Station 30 in Solvang as of the beginning of this year, and historically at Station 32 next to the San Ynez Airport. So it's not just the reservation by design.
Okay, thank you. Well, as I recall, both agreements have very specific language that exclude Camp 4 coverage from them, but we need to go back and take another look at that. I think the analysis with Bilton is interesting, and I think that this also gets to the issue of not including the taxes that go to the county fire district as a part of this, and I think that dovetails then with your understanding that that's awesome. So, I didn't want to ask a clarifying question about depth analysis, because this is something that we saw in both your 2011 proposal, as well as I think there may be some similar language in the most recent state compact that says whether grant monies come in or other kinds of things, that offsets and reduces the value of what would be paid. So I'm just wondering if you had any discussion about that, and what that meant.
Actually, our proposed terms don't include offsets. So we are essentially saying, okay, that there's no offsets. We're not, in our term sheet, we're not asking for offsets.
Well, in the future, you might want to address those issues, and that's one of the reasons that I keep.
Well, we'll take offsets, if that's what I'm suggesting. Under your term sheet, you said no offsets. And we agree.
Okay.
Well, right, but the thing is you gotta tell us if you agree sometimes. It's helpful with
Okay.
communication, that's all.
Okay.
Facilitates communication.
Before we leave, Grace, Supervisor Adams, do you have other questions on this one?
No.
So going on to section 4, it's just A that seems to, we seem to be in agreement on. B, difference in language to do with water and septic. And then everything else is, seems to be something that you haven't included on your list, to do with height and setbacks, building and fire codes, special events, honoring public and private easements, and then partnering on the sustainable groundwater management plan. So I was just wondering whether you had any comments about why those were, all of those were left out.
The tribe is not currently part of any county regulations such as those, so they were not included. As for the SGMP, the tribe is cooperating with various local groups that are working on the SGMP process.
Well, and this is another example here. So you left the last thing off because you agreed with it, and you left this one off because you didn't agree with it. So when we do these things in the future, I think it'd be best to address everything on the term sheet, and that way, if you don't have a problem with it, just put accepted, and if you have a problem with it, put deal breaker, forget it, or something. You know, that way we know what your point is on each point.
Supervisor Adams, do you have any comments on section 4 before we move to section 5 and future amendments? Okay. So what about section 5? It's to do with the Williamson Act first. It's my understanding that in order for the county to, for the Board of Supervisors to cancel a Williamson Act contract ahead of its normal expiration date, we have to make a finding that it's in, overwhelmingly, I think, in the public benefit or something like that. And we would have to look at that language, and you have to make findings as to why that is. I think 5B is also not clear. I think in your application for Camp 4, you specified no gaming on Camp 4. So this seems to, however, I do understand that your compact, and I believe the renewed compact, certainly your old compact, gave you the ability to have 2 casinos at some point in time. So that would be according to state law, and I'm sure
the other laws. So is this saying that you're reopening the door to possibly having gaming on Camp 4 in the future?
Let's not forget, this term sheet came in front of the county because the tribe was introducing or having legislation introduced that the federal level to bring this land into trust. Let's skip the application process because this was brought forth because of federal legislation, this agreement. I personally, specifically asked to have in that bill written no gaming, which is why we said comply with federal law. That's exactly what federal law will say under H.R. 1157. So let's not try and misconstrue this in any angle, suggesting that we want to have gaming out here. The fact is, the tribe follows federal law, and the tribe follows state law when it pertains to gaming. The tribe does not follow county law, nor will we ever agree to follow county law when the federal government has jurisdiction in these matters over us. Is that a deal breaker? That is absolutely a deal breaker.
You know, if I might suggest that you not get animated about it, because frankly, we just don't understand what you mean. We're just looking for clarification, and we're not trying to put you in a bad spot or anything, but I would encourage you to be a little bit more, just explain to us what you mean, and don't get mad at us, because it doesn't help the negotiation process.
Okay, so for clarification, it means gaming will be per federal, state, and tribal law, just as it says in 5B.
Okay, so what we proposed is to go create this federal law, and we need to understand what your intent is in terms of gaming. And so, are you saying that you're accepting our proposal that you're not having gaming on that site, which is what you were saying before, or are you saying you're going to reserve the right to game on that site?
What I'm saying is we are going to follow federal and any state law that applies to gaming. I mean, I don't know what else you're asking for.
Well, I think I just asked you a pretty easy question to answer, and it's pretty difficult.
And I think I gave you a pretty specific answer. We are going to follow federal and any state law that pertains to gaming.
Okay, let me try another time. What we're doing here is trying to craft a thing that both of us can take to Congress, and it will become federal law, right?
Yes.
Okay.
And H.R. 1157 specifically says no gaming, which is federal law.
Okay, we're just trying to establish, I'm not trying to be obnoxious here.
No, and I'm trying to be as explanatory and clear as I can. Mr. Cohen, do you have a copy of H.R. 1157?
Not with me right now.
Well, I don't think that's actually necessary. We're making this harder than it is. It's not a trick question. Do you want, you just commit to me that you don't want a game out there? Can you do that?
We have committed that under H.R. 1157, we will not have gaming under there. That's what brought this forward. It's difficult for me to sit here 4 years after the fact, several lawsuits after the fact, to start negotiating in areas where the tribe has certain rights that are inherent in it. I will make it very clear, if the county agrees to support H.R. 1157, we absolutely agree not to have gaming out there.
Well, that's not what I think we're doing here. Maybe I'm all mistaken here in what we're doing. We're crafting something, and it may bear the moniker 1157 on it at the end, or it may not. I don't know, and frankly, I couldn't care less. I'm not wed to a name. I just want to make sure that the conditions are right for everybody, and if we can move forward together and create a document, whatever they call it in Washington, D.C., is irrelevant to me. So I'm trying to work with you and figure out what you want and make sure that it's something that everybody can, it's good for you, it's good for everybody. And then we can go forward and take that document, whatever it turns out to be, and whatever they want to call it, to DC, and then they can pass it, and then we can all move on. And that's all I'm trying to do.
Okay. And I'll have the conversation with the board, but my understanding through our meetings up until here, up until today, was that federal and state law would have jurisdiction over gaming, and not any separate agreement or county law would apply.
Well, and
County law doesn't allow gaming, so obviously we're talking about,
Exactly.
talking about the other laws.
well, and furthermore, we're talking about what we're going to agree to. Because two parties can agree to anything. And if Congress passes it, then it is what it is. So we can make up whatever works for everybody. If we can make something that works for everybody, Congress will probably pass it, and then we'll all be at the end of this. And notwithstanding, the county didn't answer your offer earlier. You know, it is what it is. We're here now. I think we're acting in good faith. I hope you're acting in good faith, and we can do the best we can to craft an agreement that everybody can live with, and Congress will support.
All right. We just have a couple more sections here to go through. On the infrastructure, I think it's very clear that the payment of one-time traffic impact fees was not something that you're considering at this time. But the construction by the tribe of all on-site support infrastructure and services, you responded with the review of the tribal road maintenance agreement, and that's certainly something, that we can look at. But I guess I'm just looking for clarification about I don't know whether that means that the assumption is that of course you would be constructing all of that, or that that's kind of left open to another possibility.
Under 6A, of course, we are anticipating doing that ourselves.
Anything else from Supervisor Adam or the chairman or vice chairman before we go to public comment on this item? All right, let's go ahead and go to public comment on 2C. My first speaker is Andy Culbertson. Got any of our people here that can you hear that from happening again?
Andy Culbertson. The first thing I would like to say is I'll take a page out of Chairman Armente's book, is I'm not going to be able as a resident to respond to a response to the term sheet that proposed by the county that was just submitted a few minutes before this meeting started. So that's number one. Number two, I was not able in December to respond to the county's term sheet, but I'm going to prepare it right now, because it had come out very shortly before the meeting. I want to remind the two members of the Board of Supervisors that they were in the majority of a 4-to-1 vote on October 15th, 2015, opposing fee to trust on Camp 4, and there has been no change in that vote on the Board of Supervisors. As such, and Congress can't change this for you, you have to go back to the Board of Supervisors. If you're going to talk about trust, you both admonished me in November that you weren't heading toward a trust agreement, the decision hadn't been made, when very clearly your term sheet agreement is leading towards trust status, which is something the Board of Supervisors has rejected on a 4-to-1, a supermajority vote. I, therefore, urge you to conclude that without going back to the Board of Supervisors, that you are disabled in this ad hoc committee of spending a lot of taxpayer money and band money, having discussions about how you're going to put this property into trust or any portion thereof. And by the way, it isn't about 5 parcels. Under the Subdivision Map Act, a lot line adjustment could easily be done without creating more parcels that would align the areas that the county thinks it wants to take into trust. But this is not about a trust agreement, and it should not be, because there is an existing board action that says no fee trust on Camp 4. And until that is resolved, I believe this kind of discussion is outside the scope of what the board considered when it asked you to participate in an ad hoc committee. Thank you.
Thank you. Jim Marino, to be followed by C.J. Jackson.
I'm not going to touch this microphone, so you don't have to put your hands over your ears. Good afternoon, Supervisor Farr, Supervisor Adam, Chairman Armenta, Vice Chairman Khan. As was just pointed out, we got this sheet from the tribal people just now at the time of this hearing. So I made a few quick notes here, which I'll go through as fast as I can. Under the term, it says must discuss the terms of extension prior to the set end of the term of agreement. The 1999 agreement, which is the one that's in effect, or should be in effect, wasn't to be renegotiated until July of 2018 by its terms. So how there could be a new agreement that's legal, I don't know. That's a matter that may have to be determined. It says here under item 3C, tribal government-owned lands are not taxed. It doesn't say anything about trust land. Apparently that means any land the tribe decides to buy any place, any time, it wouldn't be taxed according to this agreement. Property tax is only on private residences. I mean, we all know that the property tax on commercial property is always going to be greater than that on residential. So why would there would be an exclusion for commercial property? Makes me suspicious that there's an intention to build a lot of commercial property that's going to be tax-free. And of course, the taxes, as we all know, both sales tax, property tax, and transit occupancy tax are what we use to fund the public services and infrastructure that we provide to everybody, including the tribe and the tribal members and their businesses. Down here on the future use of land that we were just talking about, we talked about gaming. So obviously the foot's still in the door with respect to gaming. Chairman Armenta points out that the Camp 4 somehow it's going to be prohibited because if they get it into trust via the bill that's pending there, that they would be prohibited from gaming. None of us are naive enough not to know that next year might be House of Representatives 1257 that amends 1157 with a rider saying, hey, that's out. They can game. And if you think that's far-fetched, take a look at what happened with San Pablo, the tribe in San Pablo, and the progression of casinos they got through the activity of Congressman Miller in amending bills and passing clandestine bills and so on. So I think there's a lot of work that needs to be done on these proposals that the tribe has just come up with, and they probably should be put into writing, made a part of the record, because they're so extensive, I couldn't do it in a few minutes. I've got to talk to you folks here today. That's what I have.
Thank you, Mr. Moreno. C.J. Jackson, to be followed by Bob Field.
Wow, there's an awful lot to digest here. Just a couple of things. Could you move to the bottom of your presentation here? There's a portion in there that I'm concerned about. And in it, if you can find it, it says that the county will join with the tribe to support a congressional action. Can we go to that for just a second? Okay. In order to streamline the approval process, if a final agreement is reached, the county will support Fee to Trust through an act of Congress on the BIA process for that part of Camp 4. Excuse me, why would we want to eliminate the due diligence that is inherently included in the BIA process? And the reason I bring that up. In the EA, which under, and this is challenged in those appeals, under 25 CFR 151.10 versus 1.1, there's the discussion of whether or not an EIS, which is a more rigorous report. And the reason that I bring that up, one element that confuses me, is that in the EA, and much of the basis of it, is a critical need for lineal descendants for housing at 143 houses. So much of the impact analysis is premised on 143 houses, but the tribe talks about a need for 1,500. So either they plan 8.4 residents per house, or the implication for the next 869 acres that hasn't been identified is housing which wasn't analyzed. And so there are concerns here that have not been rectified through proper analysis just to answer the burdens you're trying to cover through the mitigations you're discussing. So rather than go to a catch-all bill, why not allow the BIA process to complete itself, work on that due diligence, do so? The other concern I have among many, I think we need time to digest this. I think I heard the tribe say that they are not going to accede to the limitation of just 194 or 200 acres, that they are still seeking the entire property to go into trust. I think that's problematic, but it's also problematic if you were just to do the 200 acres and that go into trust. Originally, we were thinking this was going to be within the county's land use program and not a trust application. You would need to analyze what bundle of rights, current law, federal law, pertaining 25 CFR 151, to a bundle of rights that are achieved if this property goes into trust. For instance, contiguousness and all of those elements. I please ask that you study this element, and we need some more workshops to discuss this. Thank you.
Thank you, Mr. Jackson. And you know, I realize that 3 minutes is not nearly long enough for extensive comments on all of these issues. So, you know, I will remind everybody that we do accept written comments, and we'll be happy to continue to do that from everybody on these issues, and they are also posted to the website, the comment letters. So please feel free to, you know, to write additional comments that you don't have time to make today. All right, I'm sorry.
If I could just add, I think that this is first time that we've seen this, and obviously it just popped up right before the meeting, and so this is going to get discussed many more times before it's over, and everybody's going to have an opportunity to digest it and then come back, and it's going to develop and evolve over time. So I wouldn't think that you had to have your comments ready at this time. Why not?
Bob Field to be followed by Mike Brady.
Hello again, as both of you supervisors just afraid of it. As everybody here just acknowledged, there's an awful lot of stuff in this, a lot of global points, a lot of fine points. And just to try to facilitate dialogue going forward, I want to get after one narrow point, and that is the reference. The reference to Buellton as having any kind of a tough area here. And it's not Buellton, it's just a city, and that happened to be the example. Mr. Cohen said they don't consider themselves, tribal governments don't consider themselves to be cities. And I think following that, you ought to just throw that whole reference off the table. Buellton, let's just continue with the example, services something like 5,000 people, provides a broad range of services to those people at their expense, and runs no for-profit operations. The tribal government has 100 and some odd people that they provide services to, consumes a broad range of services from Santa Barbara County, and operates a $250 million a year for-profit enterprise. There is almost no similarity between the two, except the word government, which really is defined differently in those contexts. To cherry pick a favorable number out of a deal with Buellton and pretend that that somehow has relevance here is really quite misleading. And I think everybody, the public, tribe, county included, would be best to look at this in a more realistic light about the various roles and various definitions of village government. Thanks.
Thank you, Mr. Field. Mike Brady, to be followed by Doug Patel.
In the tribe's proposal 5B, waiting for federal, state, and tribal law, there was a big pushback in the response to that by Chairman Armenta, pointing out that H.R. 1157 excluded gaming in Camp 4. H.R. 1157 is not law. It's not there, it's not in place. It could be, there could be amendments to that law, there could be a whole new law that comes up. You could not do that, you could go to the BIA. There are a whole variety of ways in which you can address the camp fee annexation. So I think that is I hate to use a term, but a little disingenuous for you to not respond to Supervisor Adams' answer, a question, what do you plan to do in terms of gaming on Camp 4? Simple question. And I think that the unknown that we constantly are confronted with is a lot of what these concerns, communities' concerns are about.
Thank you, Mr. Brady. Doug Hertel, to be followed by Steve Pappas, who will be our last speaker.
Just a follow-up on the discussion earlier about gaming and the bill, so to speak, which is dead. I mean, I don't know why we're even here. This is the most insane thing I've ever seen in my life. But we're here, and we still have to keep addressing these things. But Mr. Lamalfi, Congressman Lamalfi, is in the process, he's co-sponsoring a bill to allow gambling for an Indian tribe that it was not allowed for in Texas. So there's plenty of congressmen out there that would be willing to take up that charge if it's not Mr. Lamalfi again. So I think that, you're looking at the community plan, took 10 years, thousands of lives, worked on it, and it looks like in a short couple of weeks we could be undoing all of that work for the entire valley by even addressing this situation. So I think that we've got to be really careful. We can't be giving this entity $1 billion gift. When the taxpayers will never, ever be able to make enough money to pay the taxes to fund this entity.
Thank you. Steve Pappas.
Good morning. Can we scroll this back down to the very top? What I want to point out for the public is that this term sheet, you guys can correct me if I'm wrong, Supervisor Adam and Farr, was developed by the Board of Supervisors subcommittee. So this is the board's term sheet. This is not the tribe's term sheet. And what we need to focus on, I think, is to get down to this one paragraph, which is right above the number 1. And it's very clear. And I want to park on it because I want to make sure that we all understand what we're doing here. In order to streamline this approval process, if a final agreement is reached, the County of Sloat Harbor will support the trust through an act of Congress or the DIA process. So we need to make clear, I like the board, the subcommittee to make clear that it is changing its position. Right? Telling on to Andy's comment that prior to this is the first time I've heard and seen this, even though this term sheet was developed on December 10th. I've seen it long enough to know it's alarming. The other issue is, through an act of Congress, basically cuts out the entire code. If this bill goes through this committee, and it's processed through the system, and it gets up to Congress, and it says the county of Santa Barbara now supports the bill, the subcommittee and the board are creating a federal bill. I don't know what we're doing here. It's completely out of order. As far as I'm concerned, Washington, D.C. needs to stay out of it, and I don't think the board should be in the process of supporting an act of Congress on an issue that should be settled by this community, the BAA process, and the normal system that's in place for all of us to participate. So again, take a look at that. Let's park on it. I would ask the subcommittee to revisit, especially the act of Congress, because this is the first time I heard that. If this is all about, creating a bill, I'm not sure that we understood that months ago.
Thank you, Mr. Pappas. That completes the comment on this section. I would like to reiterate what we have stated in previous meetings, that first of all, the county has filed litigation, as have other private parties on this. That litigation is ongoing. We have stated our opposition to 1157. That is still in place. I was a part of that 4-1 vote in the majority when we took that position. However, since then, the full Board of Supervisors did act to appoint Supervisor Adam and I as a subcommittee to engage in discussions with representatives from the tribe about these issues, and that's what we're doing. It is clear that whatever the result of these meetings, that will be taken back to the full Board of Supervisors. It will be agendized in open session. There will be opportunity for public comment. There will be opportunity for the rest of the supervisors that are not here and not involved with this to talk about it and decide how they feel about it. And there is no action that is final on anything that might be discussed here unless we have a majority vote of the Board of Supervisors to agree to that. Not to speak for the tribe, but it's my understanding that they have said that in the same way that Supervisor Adam and I are trying to represent the board in these discussions, that the chairman and the vice chairman have been designated by the business committee to represent them in these discussions, but that again, if there was something that ended up being taken back to them, that it would be up to a vote of the full business committee to look at that and see whether they agreed or not. So we are a long ways yet to seeing if we can come to something that both sides can agree with, to even take back to our respective entities to discuss further. So I just wanted to go ahead and say that again, although we have said it before. Moving on to our upcoming meeting dates, our next meeting that was scheduled and agreed to at our meeting in December is on January 28th. I feel quite confident that Supervisor Adam and I and our staff can meet before that to talk about the county's response to the tribe's response to the term sheet. And so I believe that we would be prepared to come back on the 28th with our more specific comments on these various points that we still are not in agreement with. So I just wanted to get consensus from the group that we'll just go ahead and meet again on January 28th as we had planned in December. That's fine. All right. We have also proposed 2 more dates in February. When we were meeting once a month, there was a concern expressed, I think, by the tribe and by members of the public that things were not moving along fast enough, and we certainly agree to that. So considering all that we have to talk about, we did propose these 2 dates in February, which follow the same pattern as we have for the last couple of months, at the same place and at the same time. So I want to go ahead and turn to the tribe and see if they have any comments on those and whether those will work for them.
Supervisor Park. Actually, I was concerned that we weren't moving fast enough, or actually didn't have the opportunity to move along in a manner which I thought was appropriate. I think if we can continue to have staff work, and then responses either from the county, 2 members of the subcommittee, or the tribes, 2 members of the subcommittee, on a timely basis. I don't believe it's necessary to meet twice a month. I believe we can do it, continue to do it once a month. I think the county's going to come back and now give us their remarks on our suggested changes. If we meet in 2 weeks, we're just not going to have enough time to review that. We're going to do exactly what we did in January, which I know disappointed Mr. Adam. We had nothing to discuss. I think if we respond in a timely manner, give us the opportunity as a board, at least on our side, to review, we could actually make further steps, further progress moving forward. I don't think twice a month is necessary for the meeting. I just think we need the response, whether it comes from the tribe or the county, in a more timely manner to give us adequate time to address it for the next meeting.
Okay. Well, let's see, we've already agreed to meet on the 28th. Why don't we go ahead, if we could, and set the meeting for February 11th and leave the meeting on February 25th off? Or are you saying that we should eliminate the 11th and just go from the 28th to the 25th? I mean, I think if we don't meet more often, then it's hard to respond back and forth. Supervisor Adams?
No.
Yeah.
The problem is what you're predicating that on is that staff's going to be working back and forth, and staff doesn't have any authority to do that. The authority lies all within the ad hoc committee. So unless we put something on the agenda for the 28th, about renegotiating the way in which we negotiate, and maybe moving to a acceptable means of negotiation possibly being written. And we might have, as we've done a little bit in the past, having letters flowing back and forth, or maybe drafts flowing back and forth that we can then put onto the website so everybody can see what's going on. And maybe we should not make a decision about that now, but on the 28th, we really talk about some proposal for modifying the way that we've agreed to negotiate. You have to understand, you are not dealing with staff. You're dealing with ad hoc committee, and that's the only people that are empowered to communicate on the county's behalf. So, not that we don't have staff support, but we take responsibility. Supervisor Farr and I take responsibility for every word that goes back and forth with you guys.
No, and I understand that. What I suggest is to have continue to work together. I meant work together as a board. I understand that the 2 members from the county are the authority, certainly on the staff. But unless we can get a response within 6 days, we're not going to have an answer for you, just like we did in December. What I'm suggesting is that your response, your direction on the response be given to your staff will send it to our staff, we will review it, and then be prepared to come in. I'm not suggesting staff negotiate, because I'm certainly not giving my staff that authority.
Yeah.
But if we're meeting every 2 weeks, then whoever is up for a response better get it out pretty quick. Which typically doesn't happen. As you guys said, you got ours today because we just met for the first time since December. So you had a day to review it. Well, are you guys going to get your response back to us in 2 weeks or in 6 days? Because I need the opportunity to review it with my entire board and discuss it openly with the advisory. That's what I'm getting at. As far as negotiating, we can agree on how we're going to negotiate now. I'll gladly send you in advance our responses. But if we do it every 2 weeks, you're not going to get our response in a timely manner, nor will you be prepared at the next meeting to speak to it.
True, well, maybe we need to,
Well,
That's why I prefer the one tomorrow.
well, I think that, I take your point, Chairman Armenta, and I know that Supervisor Adam and I, with staff, meet, several times before these meetings. I like to think that, even with the many points that we still have to discuss, that there were some points of agreement. And so I like to think that the response back and forth is going to become shorter and more focused, as we start to, nail down some issues or not. And so I do feel strongly that we should go ahead and keep the January 28th date. I will commit that we will meet as quickly as possible and try to draft a response that, certainly has to come out by the posting deadline, but before that, if possible, to give you and the Vice Chairman and the Business Committee an opportunity to respond to it before the 28th. Let's go ahead and try that and see how it works. If it doesn't work, then on the 28th, we can reconsider whether we want to meet on the 11th or not.
Okay.
But we'll go ahead and set those 2 meetings anyway, and then we can always change the 11th on the 28th if it's not working. How does that sound, Supervisor Adams?
well, frankly, it calls into question the utility of the 28th. If we just went out to the 11th, then we could have time to go back and forth and post all the stuff.
Well, so let me turn to staff because they're involved with this. Do you have any particular suggestions and see your news on it?
Supervisor Adams' suggestion is a good one. That we could wait till the February 11th so that we could post, not only posting tonight, but get it done as soon as possible to give the chairman and vice chairman time to react. That would fit our schedule. We could also do the 28th, but I think that might be better for them and the members of the public.
Okay, that's true. The members of the public need to have ample time. All right. So we're going to go ahead and cancel the meeting of the 28th, but set the meeting of February 11th. Does that work? Ms. Van Mullen? Okay. All right. All right. Then that, and then I think for number 4, clearly continued discussion of the term sheet. And is there additional information that the tribe has identified that they would like us to come back with, or from our staff, is there additional information that you've identified that the tribe would like the tribe to come back with on the 11th? Okay. Let me just ask Mr. Cohen and Ms. Van Mullen, now that the tribe has had an opportunity to do this initial response to the term sheet, then will you be planning to meet again to discuss the waiver of sovereign immunity and have an update on that on the 11th?
Let's see, is this working? We're capable of meeting. Some of the issues are policy issues, like whether or not the county is willing to do a reciprocal waiver of immunity, which I'm not sure if the board or the ad hoc committee has taken a position on yet. And then the remaining issues are minor verbiage issues in the compact waiver. So I don't sense an urgency to meet, but whenever you, the chairman and the vice chairman tell me to meet, we're going to meet.
If I might, I would say that we've already deferred that decision to council, and we're going to follow council's advice in that regard. And so, since that's kind of a threshold issue, there's no sense working on, putting a lot of work into the rest of it, and then hanging up at the end, there's no waiver of immunity. So we might as well just find that out sooner than later. We can't find an agreement on that.
And so maybe, it would be helpful for both council staffs to come up with some draft language, and then there could be, if there are alternate versions, then those sections where they're different could be, highlighted in red or something like that, so that we would have a better idea of if we're still in disagreement or not. Is there more?
Madam Chair? What I recommend is that Mr. Cole and I, we did make a lot of progress, and as he said, one of our outstanding issues is the county waiver. And so I would suggest that Mr. Cole and I just schedule a further conversation between now and the next meeting, and we can report back at the next meeting on that progress.
That'd be perfect. Okay, thank you. All right. I have one more request to speak for B from Andy Culbertson.
Andy Culbertson again. On October 15, 2016, over 100 people, members of the public, attended the Board of Supervisors hearing. Over 33 people testified, including myself, against fee to trust on Camp 4. The board took a 4-to-1 decision. It is not an answer. It is not an answer to say that you can, through the ad hoc committee, which the board established but never talked about fee to trust, that you can change that vote without going back. You are depriving the public of the opportunity to speak to this issue, this threshold and critical issue. This is unconscionable. The Board of Supervisors took that vote. Maybe they'll change it, but the public is being deprived of an opportunity to speak to the entire board as a body about this. And a lot of us took a lot of time to show up at not 1 but 2 hearings on that. And yet, somehow, this has morphed into, well, Congress told us to do it some other way, and so we're going to put an agreement together. Well, the legislation that Congress was so animated about, it wasn't Congress, it was the subcommittee. Doesn't seem to have gone anywhere. The Assistant Secretary for the Interior is still holding on to the trust application for Camp 4. I respectfully submit that this is not the time to start talking about trust when you have pending litigation on this issue and you have a stalled federal process. Basically, what you're doing is animating an agreement to revive that federal legislation. And the public deserves to speak to the entire board about this issue. And there should be no further discussions of this kind on that topic until and unless there's a public hearing of the board where the board makes a decision that it wants to go in that direction. Now, in close, I'm not, go ahead, 54 seconds. I'm also concerned that we don't seem to have any information on this waiver of sovereign immunity. This is being done by staff, exactly the way Supervisor Adams said it should be. We don't have a staff report. We don't know what's being discussed. And that's a really critical dimension. I think this is really important that at the next meeting we ought to have a report, a written report that the public can review about what's being discussed. Thank you.
Thank you, Ms. Culbertson. And just to remind you that any member of the public at any notice public hearing of the Board of Supervisors has an opportunity to speak in public comment about anything within the board's purview that's not on that day's agenda. have the speaker slip for you for this?
Put it on the other one, Supervisor Farr.
All right. Okay, just a minute. I think Supervisor Adam wants to respond to the last speaker first.
I want to respond to Ms. Culbertson. You know, I think it's being lost here somehow that it's not. Well, it's been lost here that this is a process that we were sent in. You know, you reminded us that it was a 4-1 vote to not support fee to trust at that time, and I'm going to remind you it was a 5-0 vote to send us in to have this discussion. And so it was made very clear in the very first meeting, which I know you attended, that it's distinctly possible that we are not able to come out of this meeting, this series of meetings, with a deal that's recommendable by either one of us or both of us to the Board of Supervisors. But you have to engage in that activity to find out whether or not there's something to support or not. So, you know, I'm not sure I'm asking you for a response here. I just want to publicly tell you that this is, I think you're confusing having direction from the board within this process for the ad hoc committee and having an ad hoc committee set up by the board to engage in a discussion. You see what I'm saying?
I do see what you're saying, but I respectfully disagree. The board did not set up by a 5-0
Yes.
vote the ad hoc
Yeah,
committee.
I think that I would agree. I'm sorry, Ms. Culbertson, you know, we generally don't engage in this kind of back and
It was
forth.
the county's proposal to do fee trust, not the band to do
Thank you,
that.
thank you. Actually, Mr. Marino, I did find your speaker slip and you did put the 4 on here, so.
Thank you, Supervisor Farr. For future reference, like before, I believe it's 4, I want to follow up just on something brought up by CJ, at least CJ Jackson, and that is it's extremely important to spend a little more time focusing on the distinction under the Code of Federal Regulations between Section 151.10, which is for the fee to trust transfers for land that is either within a land consolidation area, which we all know about that exercise, and that's been withdrawn without prejudice. And the other is if it's contiguous to an existing reservation. This is of critical importance because if you're, as you saw from the map that was up here earlier, it appears that when they abandoned the land consolidation effort, that they're now approaching what I call the San Manuel effort. That's where San Manuel tribe bought a big piece of property where they wanted to put their casino, and they said they were buying it for soccer field. And then what they did in the meantime then was buy all the pieces of land between their little reservation and this big piece where they wanted the casino to be located, on the basis that then it became adjacent to their existing reservation. So it kind of looks to me like maybe that's what's going on here, because we've got the existing casino, and then, you know, the intervening little piece, and then the triangle piece, and so on. Is that a bridge is being built all the way to the Camp 4 property, so the claim can be made that they can now use as a criteria to transfer the trust 151.10, which is far less than 1.1, because that's the
So,
one that
Mr.
requires.
Marino, this section has to do with additional topics that we might, or additional information.
Well, I'm
we
just
might
saying we
need.
should focus, I
So-
think, on that.
So, you know, do you have something specific you want to say about any additional information that we need to have at our next meeting on February 11th?
Well, the presentation's been made about the chain of land being built here, and I think we need to focus on the possibility that the claim can be made that is contiguous, then in the future, to the existing so-called reservation.
Okay, thank you. All right, with that, that closes public comment and our last item. brings us to the end of our agenda. Thank you, Chairman Armenta and Vice Chairman Khan. Mr. Cohen, for your presentations. Thank you, public, people that are following that are not in the room. Appreciate everybody being here and our comments, and we will meet again in the same place at the same time on February 11th. Thank you.